Anyone who tampers with the property of a deceased person without a probate or a letter of administration can incur to themselves both criminal and civil liabilities. Good afternoon. My name is Omolade Animasham, and I'm the Deputy Managing Partner of the firm. Today, I'll be speaking on grant of probate in Nigeria. First, I must state that there are basically three types of grants in the administration of the estate of a deceased. The first one is the grant of probate. This simply means that the deceased died testate. That means he or she left a will and there are executors named in the will. Also, the executors are willing, capable, and are available to act. The second type of grant is called grant of administration with will annexed. This means that the deceased person left a will. However, there are no executors named in the will, or the executors are unwilling to act, or furthermore, the executors are absent, or the executors died before application for probate. The third is letter of administration. This is where the deceased person died intestate without leaving a will. So today, I'll be focusing on the grant of probate. What then is a probate? A probate simply means the legal documentation or the legal confirmation of the authority of the executors to carry out the provisions of a will. So now that we know what is the grant of a probate, then who can make an application for such grant? An application for a grant of probate can only be made by the executors named in the will, either personally or through their legal practitioner. What then are the procedures for the grant of probate? For a probate to be granted, it depends on whether the application for the probate is contentious or not. By contentious, we mean that there are objections to the grant of such probate based on the fact that the will is challenged, or based on the fact that the appointment of the executors are challenged. So first, I would state the procedures for non-contentious grants of probate. For the non-contentious grant of probate, the first step is the discovery of the will. This means that a search is made for the will to determine whether the testator or the deceased person left behind the will. Usually, the original copies of the will are kept at the probate registry. So a search is made to the probate registry to find the will. The next step is the reading of the will. So after the will is found, the will be read at a designated time and date. But the will must be read in the probate registry or any place the probate registrar determines, and only he shall be the supervising officer in the reading of such will. Then we have the application for the grant of probate itself. So after the reading of the will, the executors mentioned in the will will make an application for the grant of probate to the probate registry. The next step is the publication of the grant in the newspaper. So after the application is made, it's going to be published in the newspaper asking for any objections to the grant of same. So where there are no objections to the grant, the probate will be granted. Now to the procedures for contentious grant of probate. The same procedure applies as the non-contentious one. However, 3 steps are included in the contentious one, which is first, a caveat. So where the grant of probate is published, a caveat will be entered for a contentious one. That's objection to that grant of probate. Where a caveat is entered, there will be a probate action, and after the probate action, there will be a decision on whether the probate will be granted or not. So the next thing I'll discuss now will be the content of the application for the grant of probate. So when applying to the probate registry for the grant of probate, the application usually includes the details of the testator, the details of the executors, a copy of the will left by the deceased, and a copy of the death certificate of the testator. So finally, any person that tampers with the estate of a deceased without obtaining letters of probate or grant of probate is liable to incur to themselves either civil or criminal liabilities. Thank you.